Good afternoon, and thank you for joining our webinar, Financial Considerations in Divorce. Today, I'm joined by David Hayek, the Senior VP of Investments, Jason Llewellyn, the Associate VP of Investments, and Mark Hildebrand, a Financial Advisor at Holistic Wealth Advisors. My name's Jenny Nelson, and we are going to spend about 30 minutes of today's webinar focused on helping you answer your questions. If during this webinar you have questions, comments, or any technical issues, you can please use them in the chat box, and we'll do our best to answer them directly to you, or we'll follow up with you after this webinar to answer your specific questions. Also, after this webinar, we'll be sending out a brief survey to get your feedback and on how we can improve this, and if you need any additional information. And we will also be sending you a link so that you can download this video and watch it on demand after today's webinar. So now I'd like to introduce Dave. Dave?
Thanks, Jenny. Thanks, everyone. What we want to do today is just take 20 to 30 minutes to give you kind of the big picture approach on divorce in Indiana and some of the financial considerations that you need to take into account when you're in the process. What we're going to assume today is that most people on this call are either contemplating divorce or are in the middle of it. That being the case, that's kind of the base point that we're going to be speaking from. A little bit about our group, just so you know who you're talking to here. The three of us, Mark, Jason, and myself, are all CPAs. We are also all CDFAs, which are Certified Divorce Financial Analysts, and nearly 100% of our time is spent assisting women and their attorneys in going through divorce in Indiana. I am an attorney, but what we are not, the three of us, are not practicing attorneys. If there are legal questions, we cannot answer those, but we can handle all financial-related and tax-related questions that would come up during the pendency of your divorce. I do want to stress again that we are not lawyers and cannot answer any type of legal question. What we do on a daily basis is primarily we act as a personal chief financial officer for those clients that are going through a divorce as well as post-divorce. 100% of our time is spent on assisting women and their attorneys. A lot of times we get questions, why do we only work with women? More often than not, the cases that we've been involved in over the last 10-plus years, the male in the relationship has the financial relationship with the financial advisor, with the tax advisor, with everybody financial. And what often happens if we're not involved is that the client settles her divorce and then is thrown into the middle of the pool, per se, of getting a tax advisor, getting a financial advisor, knowing health insurance issues, all those types of things. So what we do is we kind of act to be that one-stop source for our clients. If you have not contacted an attorney, we still meet several people who are contemplating getting a divorce because they want to know some of the financial ramifications of doing so. So we do that quite a bit and be happy to do that with you. If you do have an attorney, we've worked with nearly every single one in central Indiana that does divorce a lot, and I'm certain they'd be familiar with us and be more than happy to work with us. The primary job that we have is to kind of level the playing field, and by that we mean quite a few ex-husbands are out in the business world, in the typical case that we see, and have quite a few advisors, and oftentimes our clients kind of feel a little behind the eight ball in that they don't. This is what we do all the time. We've seen nearly every financial and tax issue that there is, and we will make sure that the playing field is leveled between you and your ex-husband-to-be. And our main job, again, is to make sure that you are 100% prepared to negotiate your divorce, which will really be probably the biggest business transaction of your lifetime. So we want to make sure that when you go into that settlement process that you are 100% feel secure that you understand the finances and the tax ramifications of your divorce. Next slide, we address a little bit about Raymond James at a glance, and I really don't think many of the people on this call care that Raymond James has had 25-plus years of profitability. But why we included this is to tell you it's more than just 3 people sitting in their office in Indianapolis. We have 10,000 associates worldwide, 6,300 financial advisors, and just a ton of resources to help us in any type of divorce situation that we become a part of. The primary job of Raymond James and their advisors across the country is we're a financial planning firm. A financial planning firm that can act as a retirement planning firm, that can act as a divorce planning firm, because really when you think about it, divorce planning really is retirement planning. how we can make a pot of money along with a certain amount of income last for the rest of your lifetime. So Raymond James is very strong in that area and will be a great partner for us along the years. All right, so we'll talk a little bit about the divorce process. The divorce process in Indiana can go a number of ways. The first we're going to talk about is kitchen table negotiations. Quite often in cases that we're involved in, husbands will try to convince their wives that they don't need an attorney and they can just settle this themselves. And if that were the case, that would be nice, but in our opinion, we do not recommend that you go unrepresented. You can still get a lawyer and sit over the kitchen table and negotiate something with your ex-husband. However, you'd want an attorney to be able to look at that. You'd want us to be able to take a look at that and maybe tweak it and say some ways that it can be improved. So it does happen in Indiana where things are negotiated, but we recommend that if they are negotiated, that you take those to your attorney and have them look at it. One of the main ways that divorces get settled in Indiana is at mediation. And mediation basically is you hire an attorney, your husband hires an attorney, and you go through the discovery process, which we'll cover in a few minutes, and you get everything negotiated and down and simplified onto a spreadsheet that shows all of your assets. You go into mediation, you select a mediator between you and your attorneys, and you go to the mediator's office, and usually by the end of the day, you have an agreement that all of you have agreed upon that will be submitted to the court. So that's probably the most common settlement procedure that we see in divorce. Another practice area or another process that we see quite a bit lately is collaborative. Collaborative practice or collaborative divorce started in Minnesota about 15 years ago, I believe, and has spread throughout the country quite a bit. Indiana is a little slow to catch on, so they're a little bit behind in the process, but there are attorneys in central Indiana that do practice collaboratively. And collaborative practice basically means you hire an attorney, your husband hires an attorney, but you all agree on the front end that this is not going to go to court. And you're going to do this in as friendly as a way as you possibly can. Sometimes you share financial advisors, sometimes you share business appraisers if necessary, but that's what the collaborative process is. If none of those processes work, you can also leave it up to your attorney and they can try to negotiate something and take it back to you to see what you think about it before you sign it. And then the last one is litigation. In the cases that we've been involved in, I would say less than 1% of those cases actually go to court where you're going to face a judge. A lot of people think that by watching TV that that's the only way to settle your divorce, but it isn't in Indiana. And again, it's very rare. You could end up in court if there's some issues that you just can't agree upon, but more often than not, you're not going to be. The main point here is don't let your husband tell you horror stories about the process. In our opinion, the husbands don't know any more than you do, and you should just tell him that he needs to direct his concerns to his attorney, and you need to direct yours to your attorney. The steps to divorce in Indiana, the first one and probably the most important step for you is going to be to select an attorney if you haven't already done so. We've worked again with nearly every single one that does quite a bit of divorce in central Indiana and are familiar with who's strong and who understands what they're doing. The first thing that they would do is file a petition for you. That petition is usually pretty short, and just so you know, you cannot be divorced any quicker than 61 days from the date that petition is filed. If there are children under the age of 18, you're going to be required to take a child class. Both you and your husband will have to take that, not necessarily together, but it's mandatory in order to get a divorce in Indiana. The next phase after the petition is filed is discovery, and that's really where we spend a great deal of our time with our clients. A lot of times our clients aren't the financial people in their household, and they're very, finances provide some level of anxiety. What we do is we hope to mitigate that anxiety by sitting down with you and helping you prepare the documents that are required. One of those documents is a financial disclosure that Indiana requires you to fill out. We will help you, and have helped plenty of our clients go through that. You also have to do a marital balance sheet, which is something that we, along with your attorney, work on and prepare it in Excel, and we try to get all the assets and all the liabilities in your marriage down on this marital balance sheet. We're going to go through and analyze tax returns. We're going to look at investment statements. We will give you quite a long list of documents that we're going to need a copy of, and if you don't have it, then the discovery process will get that from your husband. One of the main things we do during the discovery process is we assist you with your budgeting. quite often clients want to know, when I do get divorced, what's post-divorce financial life look like? What can I live on reasonably per month and expect to live on based upon some settlement options that I may explore? So we'd spend a lot of time in that area of budgeting and financial planning and divorce planning for you during the discovery phase. Next step after that is you finalize whether through any of those processes we discussed before, and more often than not, it would be mediation that you would finalize. When we meet with clients, usually it's outside of their meetings with their attorneys. First meetings, we'll get to know you and your case. The second meeting, we usually spend quite a bit of time in budgeting and answering some of your questions. The third meeting is we will have prepared a financial plan, and we go over the specifics of that plan so we understand really and very clearly what post-divorce financial life looks like. And the fourth meeting is we start looking through different settlement scenarios and making sure they fit up with your financial plan. Property issues in Indiana. What is marital property? So when you are divorcing in Indiana, marital property, as far as Indiana is concerned, is every single asset that you and your husband own, whether individually or together, is thrown into what we call the marital pot. Unless there's a prenuptial agreement that says something to the contrary. Assuming there isn't a prenuptial, which is pretty rare that we see, all the assets will be put into one pot. An exception to that could be inheritances or gifts that you may have received through your lifetime or your husband may have received during his. If those assets were kept segregated from the family and were only used on the person who inherited them, then there's a chance it could be excluded from marital property. The date of filing is the date, however date the file is chosen. We go ahead and take that date, and that's what we use as the date to value all the assets in our spreadsheet. At this point in time, and this is a point of contention and a lot of clients causes them quite a bit of angst, your husband may tell you, okay, from the date we file, all my income is mine. And to a certain extent that is true. However, most of the time during the pendency of the divorce, all the bills will be paid. The financial life as it existed before the filing date will occur during the filing date, meaning all the bills will still get paid and those types of things if your husband happened to be the only income earner. It's not going to shut you off from money for the rest of your time. Equitable division in Indiana, it is assumed it's going to be a 50-50 settlement. Most cases, you go in with that type of assumption. There are a few instances where there's more than 50% to one party, and it's usually more than 50% is awarded to that party who stayed at home with the kids and maybe didn't work outside the house. So that's where it might not be a straight 50-50 split. The next slide we're going to talk a lot about is spousal maintenance. You may or may not know that Indiana does not, and maintenance is the same word as alimony, so they both mean the same thing. Indiana does not mandate alimony, so there's no mandated alimony in Indiana. There is in other states that surround us and many other states throughout the country, but there isn't in Indiana. One type of alimony or maintenance that is available in Indiana is rehabilitative maintenance. And what that is involved is if you stayed at home with the kids and you need 2 or 3 years of educational training to get you back into the workforce, that could be a type of maintenance that your husband would be required to pay. We know it exists in Indiana, but truly it's not in many of the cases that we're involved in. Even though Indiana doesn't mandate alimony, we use it, and I would say we use it in at least 45, maybe 50% of the cases that we're involved in. The reason we do is alimony or maintenance makes complete sense in a situation when we have a very high income earner on one side, and let's assume that's husband for this case, and a lower income earner on the other. If by paying alimony, he can deduct the full amount of the money that goes to you, and even though you pick it up into income, your bracket's going to be lower presumably than his. And we'll run all these calculations, but what it does is it provides more money to you into the settlement, for one. And number two, and maybe even more importantly, is it kind of helps build a bridge between financial life pre-divorce to financial life post-divorce. That alimony, where you have one financial lifestyle while you're living off of your husband's income, may have been very comfortable, and what alimony helps to do is to build that bridge for 2, 3, 4, 5 years, however many years that we schedule the alimony for, to get you more comfortable into post-divorce financial life. Child support in Indiana, it's a pretty straight calculation. You look at both of your incomes, and if you don't have any income because you stay at home, the attorneys will impute some form of income to you. and then you look at the number of overnights, who pays for the health care, and you calculate the child support payment. It's a pretty straight calculation. Indiana just changed the law and moved child support down from 21 to 19. So once a child hits 19, they will no longer be included in the calculation for child support. Child support, as opposed to alimony or maintenance that we covered on the other side, child support is not taxable. So every dollar you receive as it pertains to child support will not go on your tax return and will not be included in your taxable income. A few financial considerations that are kind of unique to divorce, and then we'll hand it over to Jason, is a quadro exemption. And what that means, and I'm going to give you an example of a case that we see quite often, is we will have a physician husband and a wife who happen to stay at home with the kids. The physicians, usually in the cases that we see, they have a very large home with a large mortgage, they have a large retirement plan, and that's it. So if the client's 45 years old and receives one half of her husband's retirement plan, which let's just say that his plan's $1 million and she gets $500,000, that sounds great. She has $500,000, but it has to be rolled over into an IRA, and she can't touch it until she's 59 and a half. So that $500,000 really doesn't help you get into a new house, buy a car, pay for the things you need to pay for living in post-divorce financial life. So the quadro exemption says before that entire $500,000 is rolled over into an IRA into your name, you can elect to take whatever amount you would like to take without a 10% penalty because you're under 59 and a half, and use that money to pay bills, put a down payment on a house, have some spending cash for that time. So we help our clients work out what a reasonable number is, but know that that's available to you if there are liquidity concerns in your relationship or your divorce. COBRA is the last one. As long as your husband's company has 20 or more employees, you will qualify for COBRA. And COBRA, if I were to quit my job today, I would have 18 months of coverage as long as I paid for it through my employer. COBRA in a divorce process allows you to have 36 months of health insurance guaranteed. Now, you have to pay for it, and it's usually fairly expensive, but in the divorce process, it does allow you to have 36 months. That's the last slide before I turn over to Jason. What Jason's going to do is kind of take the 5 top questions that we see most often in divorce, and there's frequently many more of them. As Jenny told you at the beginning of the call, if you do have other questions, you can type those in either to Jenny or you can type them in directly to Jason, myself, and Mark, and we can answer those for you post the conference call. So go ahead, Jason.
Thanks, Dave. Good afternoon, everyone. As Dave mentioned, I'm going to cover the 5 probably most frequent questions that we receive, and as he mentioned, if you have additional questions, feel free to reach out to us through our email addresses that are on the back page of this presentation or through the chat room on the webinar. The first question that we see quite a bit is regarding Social Security, and a lot of times during the kitchen table negotiations, the husband is very unclear on how the whole Social Security payment works at retirement, and is adamant that he's not going to give any of his benefit to his soon-to-be ex-wife. Fortunately, that's not always the case. It has nothing to do with what he wants to do or how he thinks it should run from a Social Security payment standpoint. It's set up to be, if you've been married for 10 years or longer to your spouse, you will automatically receive one of 2 benefit options at your full retirement age, which as it stands today is age 66. The first option would be 100% of your benefit, and that could be next to nothing depending on what your work history has been over the course of the years. If you had a job at one point, stayed home with the kids for several years, and are trying to get back into the workforce, that could be a relatively small amount from a benefit standpoint once you reach full retirement age. The second option is to receive 50% of your ex-husband's benefit. And a lot of times what we have found is that benefit is actually going to be higher than 100% of your benefit. The caveat with that is it does not affect your husband's benefit whatsoever. So he's still going to receive 100% of his benefit, even if you're drawing 50% of that benefit at your retirement age. In 2014, that benefit amount, the maximum amount that you can receive from Social Security on a monthly basis is $2,642. They index that for inflation annually, and depending on your age today, Social Security could look a heck of a lot different 15 or 20 years from now. But this is how it stands as of today. Question number 2 who gets to claim the children as tax exemptions or dependents for tax return purposes? This question comes up in almost every divorce that we deal in, and a lot of times it gets to be almost to the argument stage because the husband is adamant that he wants to claim those dependents for tax purposes. But what is rarely looked at is what is the true economic benefit by husband being able to claim the children as dependents for tax purposes. So what we'd like to do is sit down and really analyze who is going to get the most economic benefit from being able to claim them. If the non-income earning spouse or the lower income earning spouse has a part-time job, it is truly possible that that individual is going to get more economic benefit at the end of the day because the higher income earning spouse could be phased out of a lot of the, not only the exemption, but a lot of the credits, tax credits that follow the exemptions. And we won't get into all of those today, but there are several of them that follow follow whoever claims the children as tax dependents on the tax return. So it's something that really needs to be analyzed and some thought put into before you just automatically give those away. One thing that we see with quite a few of our clients is once you are able to claim the children as dependents for tax purposes, spring break money. This is a good way to build a spring break fund and pay for a trip with the kids at spring break time just by being able to claim them as dependents and get some money back on the tax return. The next question is insurance, and this comes up quite a bit because once the divorce is finalized, the non-income earning spouse is not going to be on husband's plan any longer. So there's a couple options there. The first option is obviously COBRA. Dave hit on that a little bit. You have that option for 36 months. And as he mentioned, sometimes that's fairly expensive. So depending on your individual health situation, it could be a lot cheaper to go out and get an individual policy to cover yourself moving forward. It's one of those things that's really on a case-by-case basis, and depending on your past medical history, that may or may not be your best option. As a worst-case scenario, there is the Affordable Care Act, which would guarantee coverage of some sort that we could explore as well. Some cases, from time to time, there's quite a bit of marital debt that has been accumulated over the years, and we are faced with the question, should I file for bankruptcy? Unfortunately, that's kind of outside of the realm of what advice we can provide. That's more in the lines of a bankruptcy attorney. The one thing that we could help counsel on is, paying down marital debt prior to the division of assets. David mentioned the 401k 10% penalty exception. We've structured agreements before where we're able to take money out of a 401k pursuant to the divorce, avoid the 10% penalty, and then it's used to pay down, marital debt at that point. But as far as whether or not you should file, that's more of a bankruptcy attorney question. And the last question we thought we'd hit on is what are our fees? How do we get paid? We have a unique practice here, and we've been fortunate over the years to be able to do what we do from building our practice. We don't charge anything to consult with you in the beginning or throughout the pendency of your divorce. And the way that we would get paid at the end is if you choose to work with us moving forward and we were to manage money for you, whether that's IRA money or retirement money or after-tax money that you would receive, we would get paid by the money that we manage. We'd get a management fee from that. As part of being your advisor, we're not only your investment advisor, as Dave mentioned, we also provide the financial planning, the retirement planning, tax planning, and try and coordinate everything into one to be your personal CFO from that time on. So that's how we get paid. There's no worry of coming in, meeting with us, and that the meter's running and that you're going to get a bill for the hours that we spend together, trying to help you financially negotiate your divorce. We did provide, as an attachment to this presentation, the post-dissolution checklist. This is something that we do go through with our clients. Once the divorce is finalized, we will go through the divorce decree once it's signed by the court and returned, and put together this chart of who's going to be responsible for what moving forward. There is quite a bit of work that is required once the divorce is finalized to really put all the pieces together and get it completely finalized by changing bank accounts, closing accounts that were in joint names, moving money between the accounts, changing the investment accounts, doing all of that type of stuff once it's done. So this checklist is a good one to use to make sure that we're covering all bases in regards to the tying up the loose ends once the divorce is finalized. The other template that we use quite a bit that we have not attached to this, we'd be happy to send you an email copy if you would like. Just shoot us an email or request one through the chat room there. It's our budget template. And that's used, as Dave said, early on in the meeting process to make sure that what is going to happen with the end divorce, you have a good idea financially how that's going to impact you from a financial standpoint. So we'd be happy to share that with you if that's something that you would find of value. And with that, Dave is going to have a few closing remarks, and that'll be it.
Okay, thanks, Jason. One of the things I want to make sure we touched on was the fact that we don't charge any fees. There also is absolutely no obligation to work with us post-divorce. If you have a brother, cousin, neighbor, somebody that's in the financial business and you feel confident that they know what they're doing, by all means you can work with them. And again, there's zero obligation when you come work for us or when you come work with us. The main thing that I want you to walk away with today is yes, this is not a very fun time in your life, and there's a great deal of anxiety. What we can do is significantly mitigate the financial anxiety that's related to your divorce by being professionals that can level the playing field with your husband and the advisors that he brings to the table for his divorce. We can help you with some of your financial issues, all of them, or half of them. Whatever you choose and whatever you think makes sense is what we can assist you with. We only touched today on a few of the issues that are related to divorce in Indiana, and we would be happy again to sit down with you and talk about your specific case and give you some more background. We're happy to meet with you to discuss your specifics of your case, as I mentioned before, with zero obligation on your part to work with us post-divorce. We've worked with over 200 women and their divorce attorneys over the last 10 plus years, and if you do wind up going down this path or if you are in the middle of a divorce, we'd like an opportunity to work with you. So with that, Jenny, we'll hand it over to you and kind of do the final cleanup.
Great, thank you so much. We did receive a couple questions. We'll be sure to follow up with you directly, and also the people that requested the budget template, we'll send those out to you as well. As a reminder, after today's webinar, you're going to receive a link to a survey and also a downloadable version or an on-demand version of this webinar today. And we encourage you to please fill out that survey. It really helps us to improve these for the future and answer any questions you may have as well. So thank you so much for attending, and have a great day.